charges are from 2016, 2017. This is a death penalty case. So my first question for you is, how do you think it affects the prosecution and the defense to have started on the trial? There was a mistrial, the pandemic has happened, and now they're starting over.
Ashley, it makes a huge difference. And we're talking about Ford, obviously, but we can go back to Bob Durst. That's a trial that started before the pandemic. And the defense filed motion after motion asking the court to grant a mistrial. But the court did not. They didn't want to resume jury selection, start all over, a process that took months. So they essentially took a break of about 14 or 15 months. And in that particular case, they resumed even after witnesses had already started to testify with a mini reopening, and they continued the case. So that's going to be one of the appellate issues. And it just goes to show how much discretion judges have over their courtroom. In this particular case in Ohio, the judge decided to start all over. So it does make a big difference because you get a completely different jury pool.
You know, when you are a former federal prosecutor, I'm assuming if you have a video, you have a video. And yes, you want to use it to your advantage. But do you think the fact that you cannot see the person's face on the video is going to really hurt the prosecution in this case?
Ashley, as a prosecutor, I like to get ahead of all my evidence. The last thing I want is for a defense attorney to accuse me of hiding the ball or not showing the jurors critical evidence. So to the extent that there is video, but it doesn't identify the perpetrator, I still want to show that to the jury so they know that I'm putting all the evidence in front of them. I'm not hiding the ball. And I agree with you. One of the points that you made earlier, jurors love demonstratives. Some of them, obviously are audio learners, but other folks like video. They like images. They like to go to the scene. So you really want to present your case and your evidence in a way to sort of capture all the ways that you can educate jurors. So I really like what the prosecution is doing in this case.
If I could ask you, please, talking about a defense of other suspects, it is an argument that you hear in a lot of different trials, which is the defense puts up a defense to say it wasn't him, it was somebody else. In this case, what, if anything, sticks out to you as a potential problem or win for the defense?
Ashley, it's what we typically see in these cases when they don't have a good defense. Go after law enforcement, sloppy investigation, rush to judgment. Just like Melanie said, try to change the venue because this is a tough case for the defense. I mean, what they wanted to do is negotiate with the prosecution, take the death penalty off the table, and their client, Ford, wasn't having it. I mean, so much so that the judge ordered a competency hearing. So here you have a particular defendant who is running the show. He does not want any deal, and that's why this case is going to trial, because he absolutely maintains his innocence, and the defense is going to have its hands full because this wasn't just the first or even the second. This is the third arson that this particular defendant is charged with, and there's going to be a lot of pressure on these jurors to convict.
And you are right, Neama. I'm glad you brought up the fact, just to share with all the viewers, is that, yes, they did make a motion to have an evaluation to find out whether or not he was competent. And it did. There was some report coming back that said that he did have some brain damage, some dementia. However, the judge did deem him, after having hearings, hearing the evaluations that Ford didn't want, by the way. He didn't want those evaluations. The judge did find him competent to stand trial. There's something I noticed, and the producers pointed out, and I have to bring it up with you. Let's look at that picture, if we can bring it back up, of Durst today, because look at what he's wearing. He sure looks different to me in that, with his coat. And as I understand it from earlier, perhaps the catheter is not there, versus pictures from all the clips that they just put together and showed us, where he looks a little more leaning over and stooped over, and certainly is not wearing a jacket. What do you think the difference is today, and how do you think it affects the jury if it does, Neama?
Ashley, for the first time in months, we see Bob Durst wearing a jacket and a shirt instead of the LA County prison garb with his catheter there. So interesting decision by the defense, because we know they wanted to show these jurors how frail Bob Durst is and highlight his physical incapacity, something that they've discussed at length with the court, and make John Lewin appear overbearing. So for the first time in the history of this trial, we're seeing a very different defense strategy here. So I'm curious to know why they went in this different direction today, and whether it's something that's going to continue for the redirect and recross, and ultimately the summations and jury deliberations.
Right, I agree with you. And it's fascinating, too, to notice that some of the color of the courtroom, because we have a court TV team there, is that he stood up today, which I don't think he's always just like being a trial attorney for all of us, right? You go to court, you're prepared, you think you know exactly what you're going to do next, and then something comes up that you have to argue or put on the record. So my question for you is, if I said to you, Neama, what's the one burning issue about this trial in terms of legal advocacy that you would share with viewers, what would it be?
Actually, the burning issue is the litigants, the parties, and Judge Wyndham. Let's not forget that last week he ordered Lewin to wrap up his cross-examination. It was supposed to be done by Thursday, and yet we are here on Monday. It's continuing. Lewin was able to convince Wyndham to continue the cross-examination, and there's really sort of no end in sight as Durst takes the stand right now.
So, Neama, let me ask you this, because I know you practice in California. I think I know the answer, but never assume. We know Durst, as we pointed out today, is in a collared shirt and a jacket, and before he has been in what he's issued where he is incarcerated. In California, are you always allowed as a defense attorney to have different clothes for your client, even if they're incarcerated or not?
Yes, Ashley, California is one of those states that allows criminal defendants to wear civilian clothes, to not be restrained either with handcuffs or shackles. So that's something that we typically see. Now, obviously, this is an atypical case in every possible way, and one of which is that the defense has wanted the jurors to see Bob Durst, a frail, older defendant, in his county prison garb and in a wheelchair. So something must have happened over the weekend, maybe one of their jury consultants, or there was a change in defense strategy. But this is something new and something that we're seeing for the very first time today here on Court TV.
And Neama, great point that this is all about strategy. Remember, it's not only about arguing the law, putting the evidence out there, but also on the strategy, whether it's for the prosecution or for the defense. How can they draw the line between this was something he misspoke, didn't remember exactly because with time he's lost some of the memories, or he's lying because he did kill any one of these three individuals?
Ashley, these are great points. I want to just touch upon something that Melanie said is you always have to worry about losing your jurors, but there's a couple reasons why this is not your typical jury panel here in Los Angeles when I am. First is these jurors all volunteered. You can't force people to sit on a panel that's going to last for more than 30 days. So everyone wants to get out of jury duty. This is a get out of jury duty free card. So that was one opportunity for these jurors to get out. And the other was when they restarted the trial 14 months after the pandemic. So every one of these jurors, they may be retired, they may have unlimited pay by their employer, but they want to be here. And they were all told that this trial would last 4 or 5 months. So not your typical panel that you have in criminal cases.